Swayam Prabha. Digital India. Educated India.
Hello students, this is the time again to look at the jurisprudence and Indian legal theory, Indian legal system, and we are now on lecture number 18 and we will be discussing legal profession in India. In this lesson, in this lecture, we will also try to understand that how the legal profession today in our country is organized, whether this is organized in one day or how long has been the struggle to have a pan India organized professionals, legal professionals in our country. So, we will have a little bit of introduction where we will see that what is the diverse history and how the legal profession has been organized over centuries and how this has been given a modern shape. As we all know that the legal profession in our country is one of the oldest professions there, and therefore, its roots are there in the ancient times, in the traditional times, and what we can see that when there was the time of Manu Smriti or Dharma Shastra in the olden days, at that time also there were people who knew the laws, and when there was a question that who will interpret, who will tell the king or the officers of the king that what is the law on the point, at that time also there were people who knew what was the law, and then they had to tell the court, they had to tell the king that this was the law and this judgment should be like that. In the medieval times also there has been a system of what we say different system, like the problem of how the advocacy can be done in the Mufassil courts. So, there were Mufassil towns and there were villages, but in those times also there were some wakils who knew the law on Islam, the Muslim law, and the Pandits were there. So, there have been evolution of the legal profession in different times in the history. We will also look at the British period. The British period has been also one of the very important times, because today what we see is the outcome of the British rule in our country to a great extent. Not everything, but there are roots also in the past, and there are also the roots in the British system. So, how this British system that evolved the legal profession in India, we will also try to understand. As we all know that the Britishers, they established their foothold by passing an act that was called Regulating Act of 1773. You might have heard that at that time there were courts which were made to adjudicate the disputes mostly amongst the Britishers, and therefore, they had established the courts in the 3 fortified areas. As you all might be knowing, if you have a sense of history, you might be knowing that the Britishers, they first of all tried to concentrate in the areas of the west coast, south coast and the east coast of our country. They first of all went to Calcutta, and thereafter they went to Bombay and then to Madras, and they established their fortified area fortified towns, and the Britishers, they stayed or they resided in that fortified area, not apart from that, not beyond the fortified area. So, the Britishers who were there gradually, they only not were interested in the trade and commerce, but also they were interested in the governance of their own people, and therefore, they had established the court, and those courts were called Supreme Courts. So, the Supreme Courts were established in Bengal, in Madras, and also in Bombay. If you look at the Regulating Act of 1773, you will find that this act established the Supreme Court at the Fort William in Calcutta through the King's Charter, which was issued on 26th March 1774. This court had the exclusive rights to approve and enroll only the people from the British origin, Irish origin, and Scottish origin, and they must have been the barristers, they must have studied law, and then they would have enrolled themselves in the Supreme Court at Fort William, Calcutta. If you look at the clause 11 of this charter, you will find that the Supreme Court was empowered to admit only British barristers, solicitors, and attorneys to appear and plead on behalf of the suitors in the court. So, this was an era of exclusion. They excluded the natives when the problem mainly pertained to their decision, their problems, and when someone had to resolve it, then they did not rely upon the natives. They relied upon the British educated attorneys and solicitors and barristers. So, a new kind of development took place. When the Britishers came to our country and established their governance, then you would observe that 2-3 categories of new categories of advocates, they also landed in our country, and those were called the barristers, the attorneys, and the solicitors. So, these were the 3 separate nomenclatures which were given to the different kinds of advocates. Basically, they were advocates, but those people who had studied law and they had been admitted into the bar in Britain, and thereafter they practiced and then they cleared the examination, they would become barristers. Solicitors and attorneys, they also had to first of all take the degree in law, but thereafter maybe that they would not be actively involved in practice in the bar, and maybe that they would be giving advice to the litigants. Sometimes they would evolve strategies to the clients that how a case can be taken up, and then they would also consult with the barristers so that the matter can be argued before the court of law. So, this was the position in Britain, and that position that also was supplanted in our country, and here also a good number of barristers and attorneys and barristers and advocates, they also came to our country. You might be also knowing about the fact that when the Britishers established their governance in our country, then they gradually not only were satisfied with the fortified areas, but they also had extended their control over the inside territories of our country. And gradually in the late 18th century, what they had done, that they had penetrated into Bengal, Bihar and Orissa, and also in penetrated inside Bombay area, and after that in Madras side also. So, they were gradually going inside the territories and they wanted to also establish their court system. So, as far as the Britishers were concerned, they had first of all established companies courts. as you all might be knowing if you have the sense of history, that the Britishers, they had come here in our country by the Regulating Act, and by that act what had been done, that English East India Company, that was involving those people. So, this was a company rule. In our country, it was the rule of the English East India Company, and East India Company had also tried to not only establish the Supreme Court in the fortified areas of their settlements, but also they tried to establish other areas of the company, and those were called companies courts. The 1793 Bengal Regulation number 7 formalized first of all the legal profession in the companies courts, in which it allowed only Hindus and Muslims to serve as wakils. This word wakil, that was used during the medieval period, when the Sultanate and the Mughal period, they were having their government in our country, and when the Britishers came, they had also recognized that the wakils will be allowed in the companies courts. So, the English system also recognized the wakils for the first time by the Bengal Regulation of 1793, but this was a recognition in which the recognition was based upon religion. It was not based upon that if anyone who obtains the law degree or whoever is a wakil, he or she should be given the permission to practice in the court. There was no lady advocate which was allowed at that time. Only male Hindus and male Muslims, they could be only allowed to practice as wakils, and the Britishers, they called them pleaders, native pleaders. The people of India, they were natives for them, and they called native pleaders, and native pleaders were also allowed in Bengal, Bihar and Orissa. If you look at the other regulations, then you will see that there were several other regulations thereafter, after 1793, which also tried to regulate the legal profession in our country. For example, in the year 1814, the Bengal Regulation 27, that empowered the pleaders to act as arbitrators and provide legal opinions for fees. So, this was for the first time that there was a kind of freedom of contract, that advocates can freely enter into contract with their clients, so that they could represent them in the court. But at that moment of time, what happened, that the freedom, we can also see this freedom today. Today also advocates are free to enter into contract with their clients, and clients and advocate relationship is based upon the mutual trust. Now, we will also see about the 1833 regulation, regulation number 12, which allowed individuals of any nationality or religion to enroll as pleaders in the Sadar Diwani Adalat. Now, what was that Adalat? Sadar Diwani Adalat was a kind of second tier. The first tier was at the Mufassil area, in the Mufassil Adalats, Mufassil courts, and above that was the Sadar Diwani. Diwani meant not what we call Diwana or Diwani, it was like Diwani meant civil, Diwani meant revenue. So, all the civil matters which were to be decided by the courts in the company areas, those courts were called Sadar Diwani Adalats. So, in the Sadar Diwani Adalats, this regulation allowed individuals of any nationality or religion, for the first time, irrespective of religion, this was allowed, that pleaders can be enrolled in the Sadar Diwani Adalat. We will also move on to Bengal Practitioners Act of 1846, in which we would find that this regulation opened the office of pleaders to all nationalities and also permitted attorneys and barristers to practice in the Southern courts. So, earlier what was the rule? That the barristers would only practice in the Supreme Courts, which were established in Calcutta, Madras and Bombay, and they were not allowed to practice in the Sadar Diwani Adalat or Sadar Fauzdari Adalats. However, for the first time in this 1855, what happened, that the barristers, they were also allowed to practice in the Sadar courts. 1846 Bengal Practitioners Act, therefore, that again gave an opportunity for the native pleaders to look at how the barristers, they were arguing in the higher courts. So, that was the opportunity for them to learn the new skills what were learned by the Britishers. The Legal Practitioners Act of 1855, that enabled the barristers and attorneys of the Supreme Court to practice in the company's courts, but Indian practitioners remained barred from appearing in these courts. So, you see that this is the story up to 1857. 1857 is a very important milestone in the history of our country. As you might know that in 1857, there was a first reaction, a strong reaction, many people say it was a revolution, many people say it was a war of independence, but whatever it might have been, the fact was that the British rule in our country, that first of all witnessed a very strong reaction from the native people. So, before that, whatever English people they could have done to divide the legal profession on the basis of religion, on the basis of the distinction, that racial discrimination. So, this was happening, and the barristers were allowed to enter into the company areas. They could also practice in the Sadar Diwani Adalats, but the reverse was not true. The native pleaders, the advocates, the vakils, they were not allowed to practice in the Supreme Court, and therefore, this was showing that there was no equality, there was discrimination on the basis of race or on the basis of religion and on the basis of sex also, because even women, they were not allowed to practice before 1857. After 1857, when the British received a jolt from the native people, when in Meerut and all over our country there was a kind of strong resistance that how the Britishers were ruling. Thereafter, the administration, the British administration was changed, and the government was taken over. The East India Company's rule was taken over by the British government, and there was a direct connection of the people in our country with the Britishers sitting there in England. So, after 1857 revolt, what happened, that the change in administration happened, and British government directly wanted to intervene in the domestic affairs, and then what happened, that there were again some changes which were made. Now, first of all, we will see that the 1858 Government of India Act, you might be knowing that this act transitioned the administration from the East India Company to the British Crown, and thereafter all those Supreme Courts which were established by the company, those had also to be renamed, and the jurisdiction that also was to be changed, enlarged. And what happened, that Indian High Courts Act of 1862, that was passed, and thereafter the high courts were established, replacing the Supreme Courts and the Sadar Adalats in the company areas, and allowed them to admit and enroll advocates, vakils and attorneys, opening new avenues for legal practitioners. So, this was the time of amalgamation. The company's areas were merged with the fortified areas, and when the British government took over the administration, that can be seen also in the legal profession, that how the legal profession allowed the Supreme Court and the Sadar Adalats to enroll the advocates and wakils. Thereafter, we will also look at another milestone during the British time, that was the Legal Practitioners Act of 1879. Now, this was an act which was for all the areas wherever the Britishers ruled. So, there was no distinction that which was the company's areas and which was the area where the lot of residents, British residents were there. Now, what was the purpose of this act? This act consolidated and amended laws relating to the legal practitioners in the high courts, and this excluded the revenue agents, because the revenue agents, they were also initially they were also going to the court and helping the wakils, but after this act of 1879, it excluded the revenue agents from the ambit of the legal professionals. However, the scope was that it empowered the advocates, wakils and the pleaders to practice in subordinate courts and even in the revenue office. However, it limited access to the original jurisdiction of high courts in presidency towns. So, this was the time of distinction between the Britishers and the natives, and you could see also here after the 1879 act also this kind of distinction between the original jurisdiction of the high court and the appellate jurisdiction of the high court, that was maintained. And therefore, you must also understand that the distinction that the barristers, they would practice in the original side only, they could normally not go to the appellate side, because they were thinking that in the appellate side the disputes are coming from the mufassil areas, and therefore, they would not go there. So, in the original side there was a distinction that okay, who will be the advocates, who will be the legal professionals, and therefore, this Legal Practitioners Act maintained the supremacy of the barristers, of the advocates and of the attorneys who had the qualifications obtained from England. However, for the domestic advocates, the qualifications and rules were laid down, and the chartered high courts, they had set varying requirements for the enrollment of advocates. This act initially restricted women from practicing, and you see that till 1879 in our country, lady advocates could not have been there. So, you see that 1879 act, if you could understand that what is the importance of this act, you could see that although the advocates, wakils and pleaders, they were allowed to practice in the subordinate courts and the revenue offices, but they could not be going to practice in the original side of the high courts. As far as the powers of the high courts were concerned, section 6 of this act allowed the high courts to set qualifications and rules for pleaders and also mukhtars. So, that there was another category of person who were also included in the ambit of legal professions at that time, were called mukhtars. You might have heard, कभी-कभी लोग कहते हैं मुख्तार साहब आ गए, like that मुख्तार साहब, that mukhtars were there, the revenue agents were there, wakil sahabs were there, advocates were there, barristers were there, and attorneys and solicitors were there. Section 27 of this act allowed the high courts to regulate the advocates' fees. Now, this fees became important, because at that time it was kind of freedom of contract between the advocates and the clients, but for the first time it was observed by the Britishers that this is again going to exploit the situation, and many natives were exploited. So, what happened that for the first time, and also the second thing was that the courts were trying to get a stronghold over the native pleaders. Otherwise, they would not be giving due respect, or maybe that they would not say lordship, they will not say very high, they will not give high regard to the British judges. Therefore, what happened, that the freedom of contract between the advocate and the client, that was restricted. So, regulation of the advocate's fees. Another section 36 empowered the courts to identify and penalize the touts who were involved in the legal profession. Even today, this is a problem. If you go to the court, the premises of the court, you will see the touts roaming around, and then what you will think, that can they help us? No, they exploit the situation. And suppose if the touts know that you do not have any knowledge about the courts, you did not come to the court any time, then they will further exploit the situation. And that was also at that moment of time, because in the court the language was English, and you see that the touts, they were having some knowledge, and therefore, what they wanted to do, that they wanted to exploit the situation. And therefore, the Britishers, because they had to regulate the country, they had to deal with those people. So, first of all, what happened, that touts were penalized by this act of 1879, and whoever will be involved in the legal malpractice, they would be punished under the law. We will now see at a very significant moment when the Legal Practitioners Women's Act, that was passed in 1923. Now, after 100 years, this is 2024, 100 years before, more than 100 years ago, only the women were allowed entry into the practice in the legal profession. Before 1923, in the courts, there were no women, because they were not considered to be equal. For the first time, the act allowed women to practice law and serve as professional lawyers in the courts, and that was a significant milestone, that the women could also enter into what we call the bar, and the bar was the place where all the advocates, they would be there, organized and practicing in the court. So, why this act allowed the women to practice? Was there any movement? Was there any problem? Yes, the problem was inequality, and in the 20th century, there were a lot of movements all over the world to include women in every respect of life. And when it came to the legal profession, that was also unstoppable for the women. And in UK, another development had occurred, and the UK had passed the Sex Disqualification Removal Act of 1929, that had paved the way for the entry of women in the legal profession in Britain. So, do not think that British people, they were so advanced that they had allowed the entry of women into the bar in their native country. They had also not allowed in 1919 only, after the First World War, this happened, that the women were also allowed to enter into the bar in UK, and that was the catalyst. After 1919, in 1923, in our country also, in India, they came up with the Legal Practitioners Women's Act of 1923, and the provision was, no woman shall, by the reason only of her sex, be disqualified from being admitted or enrolled as a legal practitioner, or from practicing as such. So, for the first time, although there were advocates, there were vakils, but they could not be practicing in the courts. You might have heard about the Sorabji's family, Soli Sorabji, all of you might be knowing about. Now, you should also know that who was the first woman pleader, woman advocate of our country in the modern times. Again, that Sorabji's family, the first lady who entered into the bar was Cornelia Sorabji. Cornelia Sorabji was the first advocate of India when this Legal Practitioners Act of 1923 that was passed. So, it was a great game changer. After that, the advocates gradually also started relying upon the counsel of the women. Then we will also see that what happened afterwards. We have come on to the First World War and thereafter, but after the Second World War, the Second World War started in 1939, but even before the Second World War, there were some developments in our country that also needs to be seen. There was a committee which was constituted because after the First World War, when the Britishers knew that many people from India had participated in the First World War, they had supported the cause of the Britishers. So, what happened that to reward in another way also, in other fields they had rewarded the natives, but in the field of legal profession also they rewarded by establishing a committee that was called the Chamier Committee. And what was the reason? Reason was that the dissatisfaction amongst the local professionals, that there was a distinction between barristers and vakils, which led to the formation of the Chamier Committee. Lord Chamier was the judge of Patna High Court, and he was the chief of the Patna High Court. And what happened that this committee was established by the Britishers to look into the grievances of the legal professionals. And what happened that the Chamier Committee gave its report, and the report recommended establishing the bar councils for the high courts. And also acting upon that committee's recommendations, Indian Bar Councils Act of 1926. For the first time, Bar Council word was used in the law, Bar Councils Act of 1926. And when you look at the provisions of the Bar Councils Act of 1926, you will find that there were separate provisions for advocates, and it left the Legal Practitioners Act of 1879 applicable to other practitioners. So, advocates were separate, and the remaining advocates or remaining legal professionals, they were dealt with differently. Bar councils were established in the provinces, and those provincial bar councils had been composed consisting of 15 members, including the Advocate General, and the high courts retained authority over the advocates' enrollment. So, when you go for enrollment, even after learning the law, who will have control over you? The high courts would have the control. Bar councils had the advisory roles, and about the advocates, advocates could practice in their enrolled high courts only, and all the subordinate courts of that high court or the tribunals of that high court. This act did not cover the pleaders, the mukhtars, the revenue agents in the mufassil courts, and therefore, it failed to create a unified bar. Unified bar, when I say unified bar, it meant all India bar. There was no all India bar. Even till 1926, what you can see that there was no pan India association of the legal professionals. Britishers, they always tried to divide even amongst the legal professionals by keeping a distinction between the advocates and thereafter the mukhtars, the revenue agents and vakils. So, this distinction, the discriminatory attitude of the Britishers, that continued even before the Second World War, and therefore, the criticism has been that the limited powers of the Bar Council, exclusion of pleaders and mukhtars, led to the demand for a unified Indian bar, resulting in the formation of All India Bar Committee. And this All India Bar Committee, that was there, the establishment of All India Bar Committee, that could be possible, and this committee took long time, because afterwards what happened, that the Second World War started and it was very long. It continued for 6 years, and when in 1945 Second World War ended, then the work which was left, then that started resuming, and in the meantime our country became independent. So, what happened, that the Legal Practitioners Bill, that was the outcome of the Indian All India Bar Committee. So, Bar Committee eventually gave the report, and which was the basis of Legal Practitioners Bill of 1959. Eventually that became the Advocates Act of 1961. So, let us see some of the recommendations of the Indian Bar Committee. It said that the Bar Councils Act of 1926 could not cover the pleaders, the mukhtars, the revenue agents practicing in the Mufassil courts and the revenue office, and therefore it could not set up a unified Indian bar, and therefore this was problematic. Further, the powers which were conferred on the bar councils constituted under the act were limited, and the bar councils were neither autonomous nor had any substantial authority. So, today you might be knowing, and we will come on to that, that the legal professionals, they are organized into an autonomous body which is called Bar Council of India. It is an autonomous body, but before this Advocates Act of 1961 there was no such thing, and the advocates, they could not be given this kind of autonomy that they would decide their affairs themselves. Always they had to rely upon the judges of the high courts and the Supreme Court. With the coming into force of the Constitution in our country in 1950 and the establishment of a Supreme Court for India, the need for an All India Bar was stressed by the legal fraternity. In this situation, the Union government set up a committee known as All India Bar Committee under the chairmanship of Justice S.R. Das. So, Justice S.R. Das was the head of this committee, the chairperson of this committee, which was All India Bar Committee. In the meanwhile, there was also Law Commission's report, and the Law Commission in 1955, which was presided at that moment of time by Sri Setalvad, the then Attorney General of India. He gave his report, and he said that the reform of judicial administration must be there, and he endorsed the recommendation of Justice Das Committee, as there was a need of the creation of a unified All India Bar, as well as the establishment, composition and the functions of the state bar councils and the All India Bar Council. So, this Law Commission report, 14th Law Commission report, is also a milestone, because this was for the first time that our own Law Commission gave the report. Now, we will come on to the Advocates Act of 1961, and we can now see that this Advocates Act was instrumental in organizing the legal professionals into one body and giving them an autonomy. The autonomous character to the Bar Council of India was very significant, and we will see that the recommendation of the All India Bar Committee finally led to implementation, and the Law Commission's report also that was favorable, and therefore, a bill was brought to amend and consolidate the law relating to the legal practitioners and to provide for the constitution of state bar councils and also All India Bar Council. When this bill was to be passed, the name Legal Practitioners Bill was changed into Advocates Act. This received the assent of the President of India on 18th of May 1961. So, finally, we had our own domestic law on the Advocates Act, and we will now see that there were no distinctions as far as barristers and attorneys and solicitors and different kind of wakils and pleaders. Those were all vanished. Let us see the main features of this Advocates Act of 1961. There will be one class of legal practitioners, and all those legal practitioners were to be called advocates. Further, it took away the powers which were vested in the courts in the matter of admission of advocates. Now, the Bar Council of India was given the autonomy to enroll the advocates. Earlier, the High Courts, the Supreme Court, that was having this power, but thereafter, after this 1961 Advocates Act, the Bar Council, those were given the power to enroll the advocates and maintain the role of the advocates, and also if there would be misconduct reported from the advocates body, this was to be investigated, this was to be finalized, this was to be resolved by the State Bar Council itself. However, an appeal to the Supreme Court, that was also allowed. And further, the constitution of the All India Bar Council, that was also provided, and Bar Council was given powers to recognize the degree in law for admission as advocates. So, now Bar Council recognized the degrees. Earlier, the High Court judges, the Supreme Court judges, they could recognize the degrees, but thereafter the Bar Councils started to recognize the degree, the law colleges, and now the position was that the Bar Council constituted under this act was to be a body corporate having a common seal, and they can be also sued, and Bar Council can also sue others. So, these were some of the features, main features of the Advocates Act of 1961. Apart from those features, in this act there was the provision that the State Bar Council would be even stronger now, and it was laid down that the functions of the State Bar Council was to admit persons as advocates on its roll, to prepare and maintain such roll, to entertain and determine cases of misconduct against the advocates on its roll. So, the Bar Council was given lot of teeth, otherwise earlier the Bar Councils, the State Bar Councils, they were not having such powers. To safeguard the rights, privileges and interests of advocates on its roll, and also to promote and support law reforms. So, Bar Council was given extended mandate. They had to not only give punishment to the advocates for misconduct, but they could also safeguard the rights, the privileges, the interests of advocates on its rolls. And there was a provision for the election of the members of the State Bar Council, and that Bar Council could perform all other functions which were assigned to it by the Act or under the Act, and they could do all other things which were necessary for discharge of the aforesaid functions. And you could find that the State Bar Councils had also disciplinary committee, an executive committee consisting of 5 members, and also enrollment committee and each other committees and many other committees which might be considered necessary. After the State Bar Council, we will also look at the All India Bar Council, which is called Bar Council of India now, and you could see that the provision of having a Bar Council of India, which is called BCI. Now, this Bar Council of India consisted of Attorney General of India, Solicitor General of India as ex officio members, and 1 member elected by each State Bar Council from amongst its members. It was also provided that there will be a chairperson of BCI and a vice chairman of the BCI, and they will be elected as prescribed by the rules, and also there will be a secretary and accountant. And the Bar Council of India has also disciplinary committee, and the disciplinary committee consists of 3 members, and 2 persons are elected from amongst advocates who have the practice of at least 10 years. The senior most advocates from the member will be the chairman of the committee. Apart from disciplinary committee to discipline the advocates, there is also a legal education committee and executive committee and many other committees which may be deemed necessary. So, this legal education committee is also a very powerful committee which can raise the standards of the legal education which is there. So, you could see that, you could also know that in your law school also the legal education committee of the Bar Council of India, they might visit and they might say that your law school is not having this infrastructure or this facility, and they will not say that we will recognize if suppose if the infrastructure facility is not provided properly. So, the legal education committee of India, of Bar Council of India, is also having lot of powers, and they are given the role to make and fix the standards of legal education in our country. Bar Council of India further has lot of functions. It prepares and maintains a common role of advocates. It lays down standards of professional conduct and etiquette for the advocates. It lays down the procedure to be followed by its disciplinary committee of each state bar council. Further, the Bar Council of India safeguards the rights, privileges, interests of the advocates. It promotes and supports law reforms. It deals with and disposes of any matter which may arise under the Act and which may be referred to it by the State Bar Council to exercise general supervision and control over the State Bar Councils. It promotes legal education and it lays down standards of such education. The consultation with the universities whose degree in law shall be a qualification for enrollment of an advocate, and for this purpose they visit and they inspect the universities and they manage and invest the funds of the Bar Council. Further, they have the power to remove the names of advocates from its rolls. The Bar Council, if on a reference made to it or otherwise, if it is satisfied that any person has got his name entered in the roll of the advocates by misrepresentation, it can remove such person from the roll of advocates after giving him opportunity of being heard. Then Bar Council of India has the power at any time to call for the record of any proceedings under the Act, and further it has the power to properly and efficiently discharge the functions of a State Bar Council if it is necessary. Supreme Court rules are also there to regulate the legal profession, and there is also a separate category of advocates, those are called senior advocates. So, now after the enactment of the Advocates Act, we have only 2 classes of advocates. One is called advocates, other is called senior advocates. Who are the senior advocates? Now, the power to confer the designation of senior advocate is given to the Supreme Court and the High Court. Now, again, as far as the senior advocates are concerned, this is not the power of the Bar Council. This is the power of the Supreme Court and the High Courts under section 16 of the Advocates Act. The concerned court, if it has the opinion that an advocate has ability, experience and standing at the bar which may be important and the person is distinct and it deserves that distinction, then the court can confer upon that advocate the designation of senior advocate. Such senior advocates are governed by the Supreme Court rules and they are subject by the Bar Council of India restrictions. So, you can now understand that the Advocates Act of the country, which is of 1961, it has maintained a very simple classification, advocates and senior advocates, and therefore, the earlier classification of having lots of different advocates, different barristers, solicitors, attorneys, wakils, mukhtars, that has not been maintained. This distinction has been destroyed. This distinction, which was based upon inequality, discrimination, that is not possible now, and the present Advocates Act has organized all the advocates into a pan India body, and this organized body has lot of powers, because in the times of the Britishers there was no such organization possible. Britishers wanted to divide and rule even the legal professionals. They did not want that the legal professionals, they could deserve, they could be at par with the Britishers, and therefore, in our country a lot of advocates, they jumped into the freedom struggle. They wanted a new India, and therefore, what happened that when the new India, when the free India, when independent India was possible in 1947, we drafted our own constitution, and then it was possible that All India Bar Committee's report could be acted upon, and the Advocates Act was passed in 1961, and that was the time when everyone celebrated, the legal professionals celebrated, and therefore, now we can say that our legal profession is standing at the crossroads of tradition and modernity. The development of our legal system has been a dynamic process. The development of the organization of legal professionals in our country is shaped by the colonial past, socio-political evolution, and the demands of a rapidly globalizing world, because maybe that we are going to have a competitive legal professionals field, and Bar Council of India is also considering that gradually we will have to open up to the foreigners who are also willing to practice in our country, because after the Advocates Act, the foreigners, they could not come and practice in our country. So, this is also a challenge that is important, but as far as the jurisprudence, as far as our own legal system is concerned, the legal professionals, they have a very important role, and therefore, they need to be organized, and this has been recognized. Now, Bar Council of India is a very strong body, and which has lot of funds also for its development. Recently, you might have heard that the chairperson of the Bar Council of India is also awarded by the government, and Rajya Sabha membership has been given to the chairperson of the Bar Council of India. So, the Supreme Court has also some of the rules to regulate the legal profession, and you might know that our constitution in article 145 paragraph 1 empowers the Supreme Court to make rules with the approval of the President. There are some further sub rules which imposes restrictions on the senior advocates and every advocate appearing before the court. The court shall wear robes and costumes as from time to time to be directed by the court. There is further direction given by the Chief Justice of India that costumes worn by the advocates should be black coat with robes. So, if you go to the Supreme Court, you will find another kind of the system of dress for the advocates. There is a prescribed dress for the advocates. In every court, there has to be a particular formal dress, and therefore, the legal professionals, they must have to abide by this code of conduct and how to behave, how to dress themselves in the court. So, the way in which they dress themselves, that is different in the Supreme Court, and that is different for the junior advocates and the advocates and the senior advocates. You can just recognize senior advocates by their dress, and you can recognize the junior advocates also by their dress. So, the distinction is still made, but yes, of course, this is not based upon the race, it is not based upon the sex. So, women can also practice. Now, a lot of women are there, and nowadays there is a craze amongst the students, including girls, to study law, and in the next coming years and coming decade, maybe that there will be 50% ratio of the girls in the bar. So, I hope that now you must have understood this lecture. Thank you.